Thank you everyone for joining this session. In the interest of time, I'll just introduce Telangana AI Mission as well as the team. So today, the session is going to be hosted by Telangana AI Mission as well as NIPAM. I think you'll have an opportunity to know more about NIPAM as well during the session. But before that, I'd like to talk a little bit about Telangana AI Mission. So Telangana AI Mission is an initiative by the government of Telangana powered by NASSCOM. The year 2020 was announced as a year of AI by KTR, and that's when the initiative kind of came into place. So under this initiative, Telangana AI Mission, we host a wide array of initiatives and programs to encourage the development of AI in the state of Telangana. For instance, as of now, we have something called the DevUp Accelerator Program, where we support 80 startups. We also organize grand challenges where we partner with the various government departments. As of now, the current Grand Challenge is in partnership with the Forest Department, Capgemini, the Government of Telangana, as well as the NASCOM Foundation. So this under this initiative, startups have an opportunity to pitch their ideas and their solutions to solve a real life problem. So this is something that we do annually. We also host knowledge sessions as well as networking events. So that's just a little bit about Telangana AI Mission. If you'd like to know more, you can always get in touch with me. I think all of you do have my email ID. So please feel free to email me or just get connected to us on social media. Now, I'd also like to thank our ecosystem partners, which is T-Hub, Telangana State Innovation Cell, and Research and Innovation Circle of Hyderabad, which is also known as RICH, for spreading the word about this session. With that being said, I'd like to invite Mr. Sudhir, who's going to be the speaker for the day from the Patent Office, Calcutta.
My name is Sudhir Kumar Jaiswal, and thank you, Niyati, for providing me this platform for making aware various startups under the umbrella of Telangana AI Mission. Okay, I'm currently holding the position of Examiner of Patents and Designs in Ministry of Commerce and Industry, and my role is related to examination of patent applications in respect of computer science and engineering and allied fields. So obviously includes artificial intelligence and deep learning and such type of applications. Okay, moving on further, as you said that uh, there are certain innovative startups that are solving the grassroots problems, real life problems. So that's where the idea of intellectual property comes into the picture. So when you solve some problems and then you think that what should I do with this solution? So then you should go through intellectual property applications. So basically, now coming about the properties, there is two type of properties: tangible and intangible. Tangible property means something you own it physically, like lands, gold, car, furniture, etc. But intangible properties are that's outcome of your mind. That is creation of your intelligence. That's invention, literary, artistic works, symbols, etc. So, and then background of intellectual property means various inventions, artistic works. When you create something new that requires to be patented or should be registered in designs, and then when you register patent for that, and then that becomes the legal rights to you, that is assigned to you. So intellectual property right is actually a legal right that protects your intellectual property. That is outcome of definitely your mind. Okay, so various type of intellectual properties are there: patent, design, trademark, geographical indications, copyright, and SICLDR, semiconductor integrated circuit layout designs. So patent is basically for an invention, a problem, a technical problem you have solved, and the solution should get patented. The efficiency, improved efficiency, or something like that. You can patent either a product or a process or both. And the designs is basically related to the shape or configuration, patterns or ornaments, as the name suggests, designs. Trademark, basically you give a name to your son, something like that. You give a name to the organization or company you founded. So that logo, company logo, is falls under the trademark. Geographical indication means something very unique, having the very specific origin, geographic origin, like Telangana's Telia Rumal. Hope you are aware of that. So we give the geographical indications, rights to them. Then copyrights, basically literary artistic works, like you made some pictures or you click a photograph. Semiconductor integrated layout designs means basically composition of transistors or ICs on a particular circuit. Example like motherboard. Okay. Am I audible to all?
Absolutely, yes.
Okay, fine. Thank you. Um, what is the importance of intellectual property rights? Basically, of course, it protects your intellectual property, your creation, and it excludes others from making, using, selling, importing the patent product or the process. And you will be able to commercialize it. And of course, it's a business assets in the currently knowledge economy. So sometimes when patents comes into your mind, you think that big firms are actually getting the patents, and small firms actually not able to innovate that much. Uh, so there are some of the examples, various very salient examples like Bellatrix Aerospace and Dolby Laboratories. So Dolby Laboratories invented the noise reduction technologies, and Bellatrix Aerospace microwave electrothermal thrusters that are quite, phenomenal inventions in particular segments. Okay, so this chart actually represents when companies granted most of the patents. IBM is leading the chart, following Samsung, Canon, and TSMC. TSMC is Taiwanese semiconductor manufacturer. Huawei, Intel, Apple, LG, Microsoft, and Kolkata. IBM actually got the patents roughly around 8,600 something like that. And their R&D spending, like Roche Holding, Facebook, Intel, and of course, the more you spend on R&D, you expect that more number of patents it will yield. It's a basic example where I will try to elaborate in various IPs. In particular case, only a single IP product. You can see here the Samsung smartphone. So of course, the Samsung, there's the name itself is a trademark type of intellectual property. And then in the copyrights, you get the softwares, user manuals, of course, ringtones, startup tones. Startup tones can also fall under the trademark. Now, images, these are the copyright. The patents actually data processing, like advanced type of semiconductor chips, actually increasing the processing speeds, faster operations of.
No problem.
Uh, then the operations of the user interface, like swiping, gestures, scrolling, that eases the user work. Okay, design is basically a structure, an overall structures. Like sometimes you see that when you used to get the small screens, then bigger, then the complete phone has become the screen. Now a rolled screen also is very popular in the market. So, and the SICLD, the motherboard, as I have earlier discussed, this that is the layout of the motherboard. That is also falls under the one type of intellectual property. All right. Of course, you need resources, whether you need a single laptop or a lab. Of course, you'll require the resources. You have to apply your brain and that effort. That when all three combines, then the intellectual property actually you may yield. Utilization and commercialization. After creating the intellectual property, you may use yourself, or you may license or assign someone your rights. You may create the franchise, and then you'll be able to reap the benefits economically of your intellectual property. Right. Now we will discuss one by one various type of intellectual properties. One of them is actually the patents, and it is very important aspect of intellectual property. Patent is basically a statutory right given to an applicant for an invention, of course, for a limited period of time by the government. And in exchange of full disclosure of invention, that excludes others from making, using, selling, importing that particular product or that process. So you will disclose all the technical disclosure in your complete specification that you file. We will discuss about complete specification a bit later. And then in exchange of that, we may provide grant to the patent applications. Patent is a territorial right and exclusive right given to the applicant. Territorial means for every jurisdiction, every country, you need to file a separate patent application. So when a patent is granted in India, it is applicable to the territorial boundary of India. Term of the patent is actually 20 years from date of the filing of application in India. And if you are filing the PCT application, Patent Corporation Treaty, and in that case, in that PCT application, the term of the patent will be counted from international filing date. It is clearly mentioned over here. PCT route is basically an organization WIPO that accept the applications, and through that you can apply multiple nations, multiple countries in a one go. Okay. So innovation or invention can be very small or very big. Like innovation, like a person is actually creating a wheel out of stones, and the paper clip is also an innovation, and the bulb that you all are using in electricity right now. Scientists were famous scientists, and their invention, like Thomas Alva Edison invented the phonograph, Alexander Graham Bell invented telephones, Wright brothers invented aeroplane, Louis Pasteur rabies vaccination, and Alexander Fleming is the penicillin. The motto of this, the invention can be small or bigger, no matter what, if it is having any technical advancement or economical significance. It is very essential. One of the famous inventor is Michael J. Jackson, who is famous for his shoes that tilts up to 45 degrees. There's anti-gravity shoes. The patent application number is US 5255452A, creating anti-gravity illusions. So this is one of the famous example of an inventor invented by Michael Jackson. All right. Okay. So this one is you are quite familiar with. The stump lights. Actually, it was invented by Bronte Ackerman, the famous Australian inventor. In every cricket match, it is used separate stumps for every cricket match. So this invention is basically titled with indicating movement of an article from one position to the other position or orientation. Okay, this is one of the famous inventors, and some of the famous Indian inventions are USB Universal Serial Bus. A very small and removable storage device is capable of holding large amount of data storage. And the hepatitis B vaccine is BVAC vaccine for immunizing the patient and for prevention of hepatitis B infection in individuals. These are some of the best examples Indian inventions. Now, this is the most important part, that is the patent application filing. Once an inventor or an applicant actually invents something, he just wants to know what forms he should file, how much fees should I pay, so that I can apply for a patent applications. So basically, I've summarized all the required forms for basic applications. That is, the form 1 actually contains the details of the applications, applicants, inventors. Form proof of right can also be filed in the form 1, and further details as mentioned. So form 2 actually is the main, that is the complete specification that contains the details of the applications, wherein the details of the application includes title, background of the inventions, full disclosure, brief descriptions of the drawings, claims, abstract, and drawings. Okay, this forms the very important part of the patent applications, because the rights, the disclosure that you give is actually on the claims. Form 3 is regarding when you make some applications and you file same or substantially same applications in the foreign jurisdictions. In that case, you have to file the Form 3. Form 5 contains name of all the inventors. At the should be filed the complete specification or within 1 month the complete specification. Form 18 is 18 or 18A is request for examination. You file the applications, application has been published, and you have to file thereafter Form 18 so that your application can be examined. Form 18 or Form 18A both are for different purpose. One Form 18 is for request for examination or express request for examination, whereas Form 18A request for expedited examination. Form eligibility of Form 18A filing will be discussed later in the slides. Okay. Now, Form 26 GPA General Power of Attorney or PA Power of Attorney. Basically, sometimes you do not apply the patents by yourself, and you are authorizing an agent to work on your behalf for that particular patent application procedure. In that case, you have to file the Form 26 General Power of Attorney and or Power of Attorney. All right. Now, filing procedures, two types of filings are available. Either you can physically file the applications, or you can file in the online mode. Here is the link for online filings, and for online filing, digital signature of class 2 or class 3 is required. Okay. Uh, when you proceed for physical filing, 4 offices are there: patent office Mumbai, Chennai, New Delhi, and Kolkata. And the territorial jurisdiction is mentioned in the slides for Mumbai, for Chennai, for New Delhi, and the rest of India is actually Kolkata. If you the resident of these states, then you have to file at the appropriate office for physical filing. Whereas in online filing, you can file from anywhere. There is no bar where you have to file in this office or that. Design application, actually registration of design application can be filed at the patent office Kolkata or any of its branches of New Delhi, Mumbai, and Chennai. Uh, since this TAIM actually consists of various startups, it provides a platform to numerous startups. So here I have made this slide specifically for them that sometimes hesitates that patent applications actually cost a lot of amount. But this is not the case. We have reduced fees for startups, small entity or educational institutes very recently. So a patent application, complete procedure of the patent application could be filed less than 10,000, even very less than. You can see here in the slides that Form 1 for natural person, when applicant is a natural person or startup or a small entity or educational institute. In that case, Form 1 filing fees is 1600 rupees. For other natural person ONP, that is having some multinational companies, their fees is 8,000 rupees. Now, Form 2, there is no fees up to 30 pages or up to 10 claims. Okay, similarly for ONP as well. Form 3, there is no fees. Form 5, no fees. Form 18, request for examination, 4,000 rupees. For ONP, this is 20,000 rupees. Since this platform actually relates to startup, so for a startup, the whole procedure can be concluded in 5600, subjected to number of pages or claims. So significantly reduce the fees. I would like to add over here that if you are a startup or a small entity as such, and then in that case you have to file for Form 18 along with your proof of eligibility like TPIIT certificate or as such. Form 18 is very important for those who are startup, small entity or as such, filing the applications. I have discussed about Form 18 and Form 18A in earlier slides. Here, here it mentions the request for expedited examinations. So, who can apply for expedited examinations? You can apply through normal examination as well. Also, you can apply through expedited examinations as well. So, eligibility for expedited examination is highlighted under Rule 24C1, and there are certain criteria that to be met for expedited examinations. Either the applicant is a startup or a small entity, or if an applicant is single individual applicant, that is natural person, and that has to be a female in order to promote the patent applications and in order to promote the participation of female applicants in the patent ecosystem. Or in case of joint applicants, if there are more than one applicants and all are natural persons, and in that case at least one applicant should be female. There are more than one applicants and all are natural persons, and among them at least one applicant should be female. This is also one of the criteria to be met. If the application is department of the government or is substantially financed, wholly or substantially financed by the government, or applicant is an institutions like educational institution or other institutions established by central, provincial or state act that is owned or controlled by the government. Applicant is a government companies like PSUs as such under Companies Act. Okay, India is ISA or IPE and PCT. If an application is coming through the PCT route, Patent Cooperation Treaty route, in that case, if applicant chooses International Search Examination Authority to India, in that case also he can file the expedited examinations. If there is some agreement arrangements between the Indian Patent Office and the foreign patent offices outside, then also the applicant can file for expedited examinations. There are the provisions in the patent rules for that. You can refer Rule 24C1 in updated version. Now coming to the patent application process. So you got an idea. Now you want to apply for a patent applications. In that case, there are three routes available. The very first, I will start from the right side, that is ordinary route, ordinary applications, call it. In that case, it might be possible that your application or your invention is actually in experimentation phase. You have not concluded the complete experiment and know all the parameters of that invention or innovation. In that case, you may file the provisional specification. After filing the provisional specification, within 12 months from the date of the provisional specification, you have to file the complete specification. Complete specification should contain all the parameters, all the information, full disclosure of any invention. Okay. Or sometimes you actually invented something and you got all the details, and you have to file directly the complete specification. In that case, also you can file the complete specification directly without filing the provisional specification. The role of the provisional specification is that if your invention is an experimentation phase, and that you, in order to get the priority date, you have to file the provisional specification. After expiry of 18 months, actually, this invention, this patent application actually got published, and then we will examine that patent application. We'll issue the first examination report, and after that first examination report, from the date of issue of first examination report, you have to reply within 6 months. You can get the extension of up to 3 months by filing the form 4 and paying the fees for each of the month. I mean, for 3 times. If you want to get extension for 1 month, you have to file the fees for 1 month. You have to file, if you want to get extension for 2 months, you have to file fees for 2 months by filing form 4. So up to 9 months in case you require extension in filing the FER reply. Okay, then amended applications will be examined by examiners and report will be put up by the controllers. Then further examination report will be issued, and thereafter the hearing and further action on the disposal regarding grant or reject will be taken. Okay, similarly for convention applications, if you file convention applications in some other country and you filed over here, so after taking the priority date or filing date in the convention country, you have to file within 12 months in countries where you want to file the convention applications. Within 12 months, and then after similar procedure of FER issuance and amendments and hearing and disposal. For PCT applications, if you go through the PCT route, then 31 months from the date of the earliest priority you have taken. After 31 months, you can file in the patent, patent application in India through PCT route, and then further the same procedure, similar procedure for patent application will be processed. Some of the basic timelines. Some of the basic timelines you need to adhere to. From provisional to complete, filing within 12 months, as I have discussed earlier. For Form 3, details of the foreign filing applications. If you filed same or substantially similar applications in the foreign countries, and for that, you have to intimate by filing Form 3 within 6 months from the filing date in India, or whenever you file in other countries, from that date, count the within 6 months from that date. You have to intimate in the India. Proof of right, basically, sometimes an inventor is not the applicant. Inventor assign their rights to the applicant. Suppose you are working in some organizations like Capgemini or something like Tesla. In that case, inventors assign their rights to the organization itself. So in that case, proof of right should be filed within 6 months from the application filing date in India. Proof of right can be filed separately or can be filed in the para 12 of Form 1, which is specifically for proof of right. Form 26, if any agent is authorized by applicant, then within 3 months from the application filing date or agent authorization date. From the date you have authorized agent, after that, within 3 months, you have to file the Form 26 or GPA or PE. Form 5 is declaration as to inventorship within 1 month from the complete specification date. It is important to note that I am saying complete specification date. So you need not to file within 1 month from the provisional specification date. The date should be counted from the filing of the complete specification. Okay, you have filed directly complete specification, then within 1 month. Request for examination within 48 months from the filing date. Reply to the FER within 6 months from FER issue date if you do not take any extension, as discussed in the earlier slides, 6 plus 3 months. Then hearing submission, when hearing conducted, all the formalities should be complied within 15 days from the hearing. And pre-grant opposition, if you want to oppose some patents applications, then before the grant you can apply for pre-grant opposition, and post-grant opposition is also available within 1 year after the date of that granted applications. Application publication is specific in journal, patent office journal. Now, one of the most encountered part in the patent application is 3K, computer program per se or algorithm. Basically, computer programs or algorithm as such in its true form might not be patentable. However, that is very important to emphasize in this bold words: technical effect comprising technical advancement. These two words, technical effect and technical advancement, both are different. Technical effect means these are mentioned. Some of the examples I have mentioned over here, like reduced hard disk access time, more effective data compression techniques, improved user interface, or better control of robotic arms. These are the technical effects arising through the application of that computer programs or algorithms. And technical advancement. It is very important to emphasize that technical advancement means, suppose the technical effect that is arising out of your patent application is also present in some other prior art. Someone also has actually achieved that much of efficiency. In that case, your application might not be patentable. You have to show improvement in your application compared to the prior art. So technical effect should be there and technical advancement should be there. In that case, it may be patentable subjected to the prior art search or novelty inventive step and section 3. Hope you are able to understand this, and I hope I'm able to clear all your doubts regarding these computer program per se or algorithm. So what's in the box of Office of CGPDTM for startups? So startups basically under Startup India program, uh, who have registered through Startup India programs having DPIIT certificates, there is specific provision of SIPP. These are this scheme is introduced in 2016 for facilitating IPR procedures for startups and protect their ideas of very small and very innovative firms. Sometimes a small firm innovates something good, something that can contribute to the society in a greater way. But they do not know how to process applications, how to file the applications and further procedures. So, in order to assist these startups, the SIPP was introduced in 2016. And basically, what is the startup landscape in India? Around 69,000 DPIIT recognized startup so far, around across 6,400 and 647 countries, district of countries as of 2nd of May 2022. So government recognized around 14,000 new startups in India during 2021. In 2016 and 17, roughly 733 new startups were there, but in 2021, more than 14,000 new startups has been created. So, India's startup ecosystem is ranks number 3 among the world after US and China. 42 Indian startups currently added to the unicorn status in 2021. Unicorn status means $1 billion valuation. So taking the overall tally of such unicorns in India to 100 as of 2nd of May 2022, wherein most of these are in service sectors providing services to the people. Okay. So number of startups in the space sector also increased from 11 to 47 in 2021. So startup ecosystem is very resilient in India. Total 25,000 to 26,000. There are some data about startups, wherein 42 unicorn added in 2021, 750 plus actual institutional investors in 2021. So this is the data regarding 2021 and how startup ecosystem is actually functioning in our country. These are the 42 unicorns added in 2021. You can see Meesho, Mama, Snow Broker, Lycius. These are the unicorns having more than $1 billion valuations. So, what is the benefit for startups in intellectual property rights? Of course, reduced fee, as I have already discussed that for startups we have reduced fees, and roughly in 5,600 rupees you can apply for a patent application for the procedures. Startups can also apply for expedited examination. I also discussed with this. Now, facilitator charges reimbursed for patent application procedures through SIPP. Through SIPP schemes, if any facilitator charges occurred, that can be reimbursed through reimbursed by Office of CGP. CGP controls General Patent Design and Trademark. Now, it is very important to note that who qualify to be a startup or a small entity or educational institute. Rule 2FB clearly states about the startup that is an entity in India that recognized as a startup by the competent authority under Startup India initiative. So if you are registered under Startup India initiative, you qualify to be a startup. Or in case of foreign entity, the criteria of turnover or period of incorporation or registration as per Startup India initiative. So for the eligibility for a small entity is small entity can be of two types. The first one is manufacturing or production of goods. Okay. The second one is providing or rendering services. If you are manufacturing production of the goods, then this is the criteria to be met for eligibility of small entity, where the investment in plant and machinery does not exceed through the limit as specified in subsection 1 clause A of section 7 of this MSMED Act 2006. Okay. Similarly, the limit also is specified under clause B for those small entities who are providing or rendering the services. Subsection 1 of 7 of This is MSMED Act. You can click over here and you will find the complete act. Then there is mention the limit of investments. To qualify, Educational Institute Rule 2CA clearly states that a university established or incorporated by Central Act, Provincial Act, or any state act, and includes any other educational institute recognized by an authority designated by central government, state government, or union territories in this regard. Okay. So these are the eligibility conditions for startup, small entity, and educational institutes. So now scheme for facilitating startup intellectual property protections. SIPP scheme was launched in 2016 to encourage and facilitate the IPR protection by startups, and the same has been extended up to March 2023. This scheme is implemented by Office of CGPDTM that provides facilitators to the startup for filing and processing of their applications with respect to patent design and trademark. And professional charges that is charged by the facilitators are reimbursed by Office of CGPDTM as per provisions of SIPP scheme. The objective of SIPP scheme is to promote awareness and adoption of IPR among startups and nurture, mentor innovative and emerging idea or technologies to assist them in providing high quality IP services and resources. So, who can be eligible for SIPP? Any startup certified by Startup India Initiative by DPIIT having the innovative business, he can apply for SIPP, or any startup having an entity incorporated, registered in India not prior to 10 years. 10 years should not be lapsed after the incorporation of that particular entity. Or turnover should not exceed 100 crore in any of preceding financial year. In order to eligible for SIPP, turnover should not exceed 100 crore in any of the preceding financial year. Okay, this is the eligibility for startup for SIPP scheme. Or such entity should not be formed by splitting up or reconstruction, like one big business was there, then further splitted and now claiming for SIPP. They are not. If the turnover exceeds 100 crore in any of previous financial years, the startup cease to be exist. That entity particularly will cease to be a startup, or it has completed 10 years from date of incorporation. If you have completed 10 years of incorporation from the date of incorporation, you cease to be a startup. Of course, after getting the Startup India initiative, under the Startup India initiative, Startup Certification Board, you obtain the certificate, then you will be eligible for SIPP. There are several links, it's mentioned over here, where e-filing links, various IPR resources regarding patent, design, trademark, etc. And various forms, the second schedule. These are the links provided. Fees for the patent applications, FAQs, if there is any doubt regarding these, probably that has been covered in FAQs. I have read all the FAQs, and this is the sufficient for to clear all the doubts. SIPP and TISC, this is the links. There certain links are there. Patent advanced search systems, you can search any patent applications over this system. And digital signature vendor list, format of the specification, drawings, and other documents, you have to comply Rule 9, Rule 13, and Rule 15. It is very important while drafting the complete specification. You have to comply Rule 9, 13, and 15. Structure of the claims drafting. Claims should not be drafted in very haphazard manner. It should be consistent, wherein claim 1 should disclose all the essential features, whereas with dependent claim, other claims that should be dependent on that independent claim, they should disclose subsidiary features. So you can refer these links and you will find valuable information. Now, moving towards the designs. Designs basically judged solely by your eyes. Design aesthetical aspects like features, shape, configuration, pattern, ornament, composition of lines or colors applied to any article in 2-dimensional or 3-dimensional or in both forms. Okay, these are the designs. Term of the design is 10 years and extendable up to 15 years. Some of the examples of designs is clocks, this smartphone design, and the pattern of this sari. Further, more examples like sofa design, the hand wash. This is car, probably Veroni of Chiron, Bugatti, cycle, and this. So these are the examples of design. Design. It is very important that design will be solely judged only by the eyes, not the technical substance we are assessing in that design applications. This is one of the famous example of designs, that is shape configuration of surface pattern. 1899-1902, they have obtained a design registration for this bottle having such shape, and further this, and we have used up to 1991, 93, 2007. This is the latest one. They have the registered designs. It's a Coca-Cola bottle. Not only design applications to only one article, there can be the set of articles. It might be possible that a number of articles are combined together, where in each of the articles should resemble similarity, same general characters. Like this cup is having this design, then all these cups should also contain this type of designs. This shoes also, and this sofa set. So filing of design applications is basically you can physically file in Delhi, Mumbai, Chennai, Kolkata, and thereafter digitization. It will be processed to electronic processing module, or you can file electronically directly through the provided link, and then it will be electronically processed. Thereafter, further action will be taken on that design application, like examination, registration, publication, or post registration. For physical filing, DD in favor of control of design should be payable at Kolkata. Prescribed fees should be paid in the favor of control of designs. This is the format of design registrations, where you get the design number, dates, and further details in the name of applicant name and address. This is the design applications. Similarly, patent applications are also kind of similar. Certificate will be issued by the Office of CDP. Okay. Now the trademark. You give a name to your company, you want to register that name, that falls under the trademark applications. So a trademark is basically a mark adopted for distinguishing trade, goods, or services from one trader to another trader. Okay. So Microsoft versus Apple, they have both the trademarks of their names. Importance of the trademark is crucial, because so that your goods can be identified that particular name. Okay, it provides protection from potential infringement. It also creates the assets for you. It provides you exclusive right to use that on your goods or services. Of course, it provides trust, and it will contain the registered symbol, R symbol. You mentioned R symbol. You might have come across this type of symbols having R after the name of a particular organization or product. So various type of trademarks are available. Product marks, of course, an organization who actually make the products, manufacture the goods, they get the product marks. Example of them as Relaxo, Bisleri. Service marks, who renders the services, like TripAdvisor provides you services, and Infosys provides services in software center. Okay. So product marks, service mark. Manufacturing the goods is product marks, and providing rendering the services to falls under the services marks. The certification marks, generally when an organization achieve up to some standard, this certification marks is issued to that organization on application. Okay, these are the certification marks like BIS, Hallmark, and generally you can find it on jewelry, Eggmark, ISI, or FPO, some agri products FPO marks. Tagline slogan also can be registered. In this Nike example, you can see that Nike is also registered, that tick mark is also registered. There is slightly R is written over here. Okay, just do it. That is the tagline and slogan. It also registered. It is also registered trademark. Life's good, open, happiness. There is also probably TM is there. So it's under application. It was under application phase at that time. Some of the important marks are sound marks. Hopefully you are able to listen this sound. Okay, it is. This is the trademark of Intel. Intel that manufacture the semiconductor chips, and this is one also. So sound marks also provided. This is for Nokia in our children days, good old days. Shape marks also given. The Coca-Cola also achieved the got the shape mark of their bottle. So these type of marks also given by the Office of CPTM and the trademark category. Collective marks, particularly it represents a category. Like if you achieve the CA mark, that means you are qualified to qualified to be a CA. And Confederation of Indian Industries. These are marks refers to when you achieve some standard, like you have achieved a CA degree. In that case, you can use these type of marks. Series and associated marks. Sometimes you see that trademark that Tata company is using, Tata Sky, Tata Steel, different sectors. They are using the same name, Tata, but some distinguished further name, that is with steel, power, solar, or sky, or tea. So these such type of marks are called associated marks. Similarly, in case of Amul Paneer, Amul Doodh, Amul Ice Cream, Amul Cool Care. These kind of trademarks are falls under the category of series and trademark marks, series and associated trademarks. So sign of trademark can be TM and R. TM is eligible up to when the application is pending in the patent offices. Okay, in that you can use the TM marks up to that. When registered, you can use the registered marks. TM indicates that your application is under processing. This link provides the various classes of trademarks. Roughly 45 classes are there. You can visit this link and find the copyrights. Another type of intellectual property rights is the copyrights, generally for literature or artistic works, or dramatics or musical works. Copyrights comes into the picture. You have watched the movies, cinematography, films, sound recordings. It provides a bundle of rights, means you will receive the rights of reproduction, communication to the public, adaptation, or translation of your work. So copyright itself is a bundle of rights. Various type of rights you inherit when you obtain a copyright for some your creation. Similarly, for cinematographic films, sound recording, photographs, posthumous publications, anonymous and pseudonymous publications, works of the government or international organizations. The time limit we will discuss in further slides. I have discussed about the bundle of rights. Automatic rights means you publish something somewhere, so it got the automatic right. It provides exclusive right to creators for their original work. These are the sections mentioned, work in which copyright subsists. It allows the applicant or the copyright owner to choose the way he wants to make available his work to the public. Provides prevents unauthorized copying or reproduction. So, of course, copyright cannot protect an idea. You have to create something, and that can be copyrighted. However, in a patent application, if you have some idea and you know how to do it, you may file an application. But in copyright, you have to produce something. There are the various terms of the protections, like for literature, artistic, or dramatic or musical work. That is the life of the author plus 60 years. That is the term of the protection for this copyright. Cinematography, films, or sound recording for 60 years from the date of the publication. Broadcasting, reproduction rights, like Hotstar, streaming, the IPRs. These are the 25 years from the following year of the broadcast. Performance right, you stage performance, like Michael Jackson performances also. 50 years from the year following the year on which performance is made. Okay, so who are all the authors of the work? like who are eligible to file the copyrights. For literary dramatic work, author, musical work, music composer. For art, who create some artistic work other than the photograph. Then artist, photograph, or the person who is taking the photograph, cinematographic films or sound recording, producer will be the first owner of the copyrights. And literary, dramatic, musical or artistic work, that is computer generated. In that case, the person who causes the work to be created. Various subject matters of the copyrights, like literary works, someone published the book like Peter Norvig and Stuart Russell. They have published the artificial intelligence, a modern approach for the edition. Their work is copyrighted through Pearson Publications. Dramatic works, again, some drama or some performances, some such type of works are subject matter of copyright. Sound recording, music composing, artistic work like painting of the Mona Lisa and other paintings, they fall under the copyrights. Musical works, notes, cinematographic films, you see that warning always in every films or every serials. That's copyright warning. Now, rights of the authors of copyrighted works. Two types of rights. Economic rights. Suppose you have created something and you have copyright over there, over that particular creation, and you may assign that, transfer that right to others for a sum of money or royalties. That is called the economic rights. Moral rights basically refers to such creations like Mona Lisa, that painting. So it's a non-transferable rights. It remains with the author. He does not want to transfer the rights to the others. In that case, it will fall under the moral rights. Application procedure, simply filing the form 14. And the prescribed fees for copyright applications are for different category. There are different type of fees. Literary, dramatic, artistic, musical work like 500. Artistic work for 2000. There is a difference between artistic and this artistic. Actually, some artistic work actually you use on some for goods and services. You mark that artistic work on that particular goods and services, so that that come into the market. For such type of artistic work, the fees is different. Sound recording 2000 and cinematographic films 5000 fees. These are the prescribed fees different for different class of works. SICLDR, semiconductor integrated circuits layout design, basically refers to the composition of electronic circuitry that contains the various electronic elements like transistors, registers, etc. Basically, a chip design. I would simply say that particular layout design is falls under the SICLDR, semiconductor integrated circuit layout design registry. Okay, so that is designed actually to perform a electronic circuitry. SICLDR registry is in Delhi. So you can file the application in SICLDR registry Delhi. Oh, this is the procedure for SICLDR processing and the applicable fees. You may refer to this. Geographical indications. Actually, it is the invaluable treasures of incredible India. Basically, if a product is originated somewhere and that product should be identified in that particular region for that particular name, that falls under the geographical indications. Like something is famous for somewhere, like Makrana marble, Rajasthan Makrana marbles, Darjeeling tea, uh, such type of things falls under the geographical indication categories. Some of the examples is Darjeeling tea, Ratlami save, Kanchipuram silk, Makrana marble. They are registered under geographical indications. Further examples: Telangana's Telia Rumal, Nagaland's Naga Mircha, Madhubani painting, Kashmir saffron, Katputlis of Rajasthan's. Andhra Pradesh's Bobili Veena, Telangana's cereal painting, Nagpur oranges, Tamil Nadu's Nachiyar coil, Puthuvilatku. Andhra Pradesh's Tirupati Lattu. They all have the geographical indications registered. So coming to the end of the sessions, you can find IP, intellectual property, everywhere in your daily life. Some of the important summarized terms for validity of various patent designs and trademark geographical indications. These are 20 years from filing date, as I will discussed. Designs 10 years and further extendable up to 5 years. And trademark is actually subjected to renewal. Initially, it granted up to 10 years. Geographical indications up to 10 years initially and indefinitely subjected to the renewal. Copyright in these cases lifetime author plus 60 years. I have discussed all these terms of various intellectual property rights. So who can apply intellectual property rights? Any individual or firms or a small entity or their legal representative. It is very important to note that all IP rights, all intellectual property rights are territorial in nature. Like if filed in India, it will protect you in India only. So, some points to remember: first, protect, then publish, of course. And then rights are territorial, as discussed. Registration it is by sovereign entry authority, Government of India. Rights for limited period of time, no automatic relief. Need to file an infringement suit. Renewal fees should be paid for some IPRs. In case of copyright, you need not to pay the renewal fees. In other cases, you have to pay the renewal fees after lapse of term. Of course, appointment of patent agent is not compulsory. Applicant can file itself and can file the applications by himself. For further training, you may contact the RG and IAPM. The details mentioned over here. Thank you for slides. Thank you for cooperating with me. If any doubts, if you have, you may please ask.
Hi, Mr. Sudhir. Can I request the audience to just raise their hand if they have any questions? I think Mr. Chandra has.
Almost all the doubts have been cleared in the slides itself. If you have any other doubts that is not mentioned in the slides, welcome.
Yeah, I have a question. Can I go ahead?
Yes, sure.
Okay, thanks for the presentation at the outset. I was curious when you said it's not territorial. That means we have to file for a patent in each of the geography where I want to protect myself, correct? Be it US.
Yes, you are right. It's a territorial patent is a territorial right. Means if you file in India, of course, it will protect you in India only. If
Got
you
it. So what is it?
yes.
Yeah, please go ahead.
If you want to get protected in US, you have to file in the US. Therefore, in order to ease the process, the WIPO PCT procedure came into existence. You filed over here, and within 12 months, you file it through the PCT route. In PCT routes, you get all the designated state where you want to file. You may file. Also,
Okay. So
one more
understood. So you're saying I can file in India first through the PCT route, and then within 12 months I can, if I want to apply in US or Australia, I can go take the PCT route to use the what I filed in India as a base, is it?
Yes. Of course.
Okay, got it. And what is the typical cost? Let's say I want to file something in US or Europe, right? Could you paint a picture of the cost? What is the cost for filing the patent? And also you spoke about renewing the patent every year. I need to make some payments, right?
Yes.
If you could you please put some color of that?
In India, if you file a patent, roughly it depends upon the category of the applicant. So if applicant is a natural person, a startup or a small entity or educational institute, as I already mentioned, roughly 6,000, and it depends upon the number of pages in complete specification and number of claims itself. Okay, so in other jurisdictions, of course, their processing or filing or their fee structure are different. You may refer to their websites like USPTO, EPO. Regarding that, in India, it's a quite nominal fees. We have very reduced fees so much that anyone having an idea is able to apply the patents. He should not hesitate that that much amount of fees is being charged by the patent officers. So we have reduced quite much the fees. For other jurisdictions, you have to refer other websites like they are charging in dollars or euros or something. Okay. Any other questions?
Thank you.
Kanu Prasad.
Hi, if nobody else is asking, can I ask a question?
Yes, of course, you can ask.
Okay. Hi, this is Maneet from Imagine Reality. I was given to understand when I had last consulted an IP lawyer that there is a difference in the way patents are awarded for software code. So, in case we build an application, the way it is done in India versus the way it is done abroad. Could you please expand on that part?
See, Patent Act is actually, of course, applies to the territory itself. So US legislation is also different. EP legislation is also different. So sometimes they award patent, they grant patent for software or computer program per se as such. But in India, we do not grant generally the patent for specifically for algorithms or computer programs in its true form. As I already discussed regarding this, if your invention is having any technical effect, like as mentioned or as such, okay, in that case, if that technical effect your invention exhibits and that comprises the technical advancement also, in that case, you need not to hesitate in filing the patent applications. Technical advancement means it might be possible that the technical effect that is arising out of your invention is also present in some prior art. All right. In that case, your application does not hold the technical advancement, so it might not be patentable in that case. So if it comprising the technical effect and technical advancement, you need not to hesitate. Further procedure rests on the office. So you file the applications, and of course it will be examined accordingly. Okay. In US
Okay.
EP legislations, both all are different.
Okay, I get that. So just to clarify, what you're saying is that software by itself is non-patentable within Indian law, but it might be patentable in a different jurisdiction or a different territory. And we could do that, but that wouldn't be applicable in India.
Yes, of course.
Okay, understood. But in your understanding, are there other jurisdictions that do grant patents to software?
Specifically software, I do not think that any other jurisdiction will grant. But we have seen the applications where US is that actually grants some of the applications, not completely software. Of course, they will look into the substance of the inventions. If there is something in substance, then of course. Furthermore, the software falls under the category of the copyrights. So if you see in the any software that's actually copyrighted. So there are
So
other things.
So essentially, if we develop a software and it has a particular application, but it's only a software, it does not have any hardware application at all, then in India, the only way we can be protected is via a copyright, and that's basically it, right?
Of course, in India, you might not be able to get the patent over pure software applications.
Okay, got it. Thank you very much.
Okay, any other questions?
Hello. Am I audible?
Yes, you are audible, please.
Very good afternoon, sir. Hello.
Yes, speak.
Sir, actually, I was very curious to know that how much time does it take if an entity applies for a trademark registration for its logo?
Okay, how much time does it take for a trademark to register?
Yes, sir. Yes, sir.
There is no fixed time, but if you get the applications, you file the applications, of course you will get the examinations of particular trademark, and after that, when you get the examination report of that particular trademark, if it is granted, then it's fine. If not granted, you may file the review petition within 1 month of date of refusal, uh, and you should ask a copy of that refusal grounds for refusal after getting refused, and then within 1 month you can file for review petition, and further it will be examined and further decision will be taken on. Okay.
Okay. Okay, sir. Thank you.
Okay. Okay, any other questions?
How much time does it take if an entity applies for a trademark registration for its logo?
Okay, how much time does it take for a trademark to register?
Yes, sir. Yes,
It,
sir.
there is no fixed time, but if you get the applications, you file the applications, of course you will get the examinations of particular trademark, and after that, when you get the examination report of that particular trademark, if it is granted, then it's fine. If not granted, you may file the review petition within 1 month of date of refusal, uh, and you should ask a copy of that refusal grounds for refusal after getting refused, and then within 1 month you can file for review petition, and further it will be examined and further decision will be taken on. Okay.
Okay. Okay, sir. Thank you.
Okay. Okay. Any other questions? There is very
Uh,
less participants. 48 participants are there.
Hello.
Yes, 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 please.
Yeah. So myself Abhishek Gaikar, and I'm from AIC CCMB Hyderabad. I want to ask one question regarding this grant of the patent. For example, I am a startup who have designed some sort of an product and or a technology who got a who got approved patent. Okay. But in that case, due to some problem, the grant is not applicable for that. In that case, if I have a patent, I will start making a business, right? So when the grant application is getting rejected, so in that case, what could be the scenario that will be happening in case of a
If, if,
government?
if your patent has not been granted, of course, and you are not satisfied with the decision, you may go to the various legal proceedings or infringement legal proceedings, like you are refused the patent as such. So, patent office job is complete whether granted or refused or whatever. And if you are building on that particular applications like products in your no startups or something like that, so you may build a product, but it might be possible that that is some other persons who also have such type of invention or innovation, such type of technicality, might infringe, might file an infringement suit against you. Okay, so it will be difficult. If your patent is granted, you are well protected. So if it is refused, caution should be clear. Okay.
Okay, sir. One more question is that, for example, if I have a patent, okay, and I started making a business before the granting application, is it a valid one, or we have to start the business after granting of the application?
Of course, you can start the business before, but actually it is advisable to always to of course you have granted the patent, you got a granted patent. Then after you feel secure that now it's my time to establish myself in this particular section or particular area, then it will be better to do the business after the granted. You may use, but of course for your security and all these things, should better you should better build the startup after the grant of the patent in commercial sector.
Okay, okay. Thank you very much, sir. It was a great presentation. Thank you.
Okay, any other questions?
So this is Sandhya.
Yes.
So for our company, we have a logo and a slogan associated with that logo.
Mhm.
So should I register the logo and the slogan separately? Because
You may it's up to you. I have already discussed regarding this the Nike example. Hope you are this the Nike that is actually text separately, then symbol is separately, then slogan is separate. You can apply it differently.
okay, thank you.
Okay, any other questions?
I think, Mr. Sudhir, that will be it. So I'd just like to thank you as well as Arnav for this opportunity and a great presentation. And for everyone asking about the recording, I will share further communications on email. And please do sign up for the certificate if you do want the certificate. Yesterday I shared an email and the link, the Google form link will be there. So you can add your details and we will be sharing the certificate shortly.
Thank you.
Okay, it was a
Thank you, everyone.
great interaction with you, all the startups actually. So,
Thanks a lot.
part of this session. So, if there is no other questions, shall we close the session?
Okay, sir. Thank you for your insightful information today.
Okay, thank you. I'm closing the session.
Thank you all. We are ending the session.